application reject ಮಾಡಕ್ಕಾಗಲ್ಲ. Anything else? We'll fix it. ಯಾವತ್ತು examine ಮಾಡ್ತೀರಾ, one day you take it and finish it. So, the petitioner is before this court.
Only documents.
Documents confront ಮಾಡೋದು ಬೇಡ ನಿಮ್ಗೆ.
Documents ಮೇಲೆ
ಅಷ್ಟೇ,
ಮಾತ್ರ
yes.
evidence ಅಷ್ಟೇ.
The petitioner is before this court calling in question order dated 10/6/2024 passed in CC 55795 of 2021 rejecting an application filed by the petitioner under section 311 of the CRPC. Heard ones. The petitioner is the accused, the respondent, the complainant. The two have a transaction. The transaction leads the complainant to the court of the learned magistrate invoking section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. The next para. The issue in the list does not concern the merit of the matter, merit of the claim of the petitioner or respondent or the defense of the petitioner. The petitioner files an application under section 311 of the CRPC seeking recall of PW1 for further cross-examination. This comes to be rejected in terms of the impugned order on 10/6/2024, which has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that no doubt he had filed two applications in the past, one on 4/1/2023 for further examination of DW2 and on 23/5/2023 for examination of the FSL. Bank manager. Examination of the bank manager. The learned counsel would further submit this was a third application filed under section 311 and the permitting of further cross-examination was imperative in the light of the examination of the bank manager, which happens pursuant to the application being allowed on 23/5/2023. The learned counsel appearing for the respondent would, however, refute the submissions to contend that the matter was at an advanced stage and the petitioner comes up with some application to only to drag the proceedings and therefore this should not be permitted. He would seek dismissal of the petition. I have given my so-and-so. The transaction between the petitioner and the respondent is a matter of record. The proceedings before the concerned court, in the proceedings before the concerned court, petitioner accused files his first application under section 311 on 4/1/2023, in which the defense witness was further examined. Defense witness number 2 was further examined. After which, on another application on 23/5/2023, the bank manager was examined, the FSL report that was received. After which it transpires that the petitioner files an application under section 311, yet again, seeking further examination of PW1 in the light of the evidence of the bank manager who was examined pursuant to an application earlier allowed. This comes to be rejected. The reason so rendered for rejection of the application is that the application is so filed only to drag the proceedings, and the matter was of the year 2016. The reason so rendered is found in paragraph page 3940. The reason so rendered would run foul of the judgment rendered by the apex court in the case of Varsha Garg so-and-so. In the light of the aforesaid reason in the application seeking a further recall of the PW1 for further cross-examination, as also the judgment of the apex court in the case of Varsha Garg Supra, I deem it appropriate to grant one opportunity to the petitioner to further cross-examine PW1, the documents that he is wanting to confront on him. The concerned court shall endeavor, this shall be the last straw of opportunity to the petitioner, and applications of the kind would not be entertained in future. For the aforesaid reasons, the following order allowed, quashed, application allowed. The concerned court shall permit further cross-examination of PW1 on a particular date and with a condition that the petitioner would conclude the further cross-examination PW1 on the same date. No application of the kind shall be entertained in future. Yes.
Public.
Next.
undertake to appear for respondent number 2, my lord. Just yesterday I have received set of papers and wakalat, my lord.
Learned counsel Kishan Allah.
Yes, my lord, Kishan, GS.
GS Kishan.
Kishan, yes, my lord.
Learned counsel GS Kishan accepts notice and submits that is entered appearance for the second respondent complainant.
Any day next week, my lord.
319, yes. List the matter on 20th September. Interim order subsisting shall continue to the next date of hearing. Next. Non-signatory to the check. Who has signed the check?
Petition number 3.
For I undertake to appear for the respondent in this case.
One moment, sir, one moment. Petition number 3.
Madam.
Who is she?
She is the proprietor of the petition number 1.
Who are you? Husband.
Yes,
Ah.
petition number 2 is the husband, my lord.
All right.
Liquid check, my lord.
Partnership concern or proprietorship?
Proprietorship, my lord.
Where is the check?
Annexure, see page number 30, my lord.
She is the proprietor, is it?
Yes, my lord.
Then we will stay against the husband.
Your Honor, both are the proprietor in this case.
Both are, huh?
Both are proprietor, Your Honor.
Both
are
are
proprietors.
proprietors, sir. Yeah, both
Yes,
are
sir.
proprietors, sir.
Yes,
There
Your
can't
Honor,
be
because
two proprietors. Yes,
proprietor of Siri enterprises.
correct, sir.
Matter is set forth for cross examination of PW1. Your Honor.
No problem.
Before the-
Yes. She is not, who is the signatory to the check, sir?
Siri enterprises, sir. Siri enterprises.
Who is the signatory to the check?
Petitioner number 1, who is represented by the both.
Really, the petition number 1 has signed something. Yes, sir.
Petitioner number 1, Your Honor.
Petition number 3 is the sign. In the annexure, the page number 30, my lord, in the check.
Where is the deed of, what is this organization? Siri Enterprises, sir.
Yes, my lord.
How do you say it's a proprietorship concern? You have taken the defense, reply ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ? ಯಾಕೆ?
It's, sir.
Notice reply ಕೊಡ್ಲಿಲ್ವಾ? Anyway, file your objection, sir.
Yes, Your Honor.
Heard the learned counsel appearing for the petitioner and the respondent. The learned counsel for the respondent seeks 2 weeks' time to file statement of objections. Learned counsel Sunil Narayan appearing for the petitioner would submit that Siri Enterprises, the first accused, is a proprietorship concern and the sole proprietor is the second petitioner. The third petitioner, who is also the signatory to the check. The counsel would submit that the second petitioner has nothing to do with the proprietorship of the company, nothing to do with the company whose sole proprietor is the third petitioner. The learned counsel for the respondent would seek to refute the submission and file a statement of objections. In the light of the second petitioner not being a signatory and the concern being the sole proprietorship concern, till the filing of the statement of objections, there shall be an interim order of stay